There we go. It says good to go.
Is it on? Okay.
Okay, we are
Oh,
on.
here it is.
Let them in. Oh, it's just you and I.
Oh.
There were more people waiting.
Hang on, I'm putting it back. I'm putting it back. I had to switch to, I had to,
Did it kick them off when we?
He's talking.
She's
sorry,
muted.
I had to switch to, are you ready for all of them?
Yes, ma'am.
I had to switch to host to get it on YouTube.
Okay. Right. Good morning. If everyone would please take a look at the participants before we go on the record, I want to ensure that we have everyone here who is expected. So petitioner and respondent, if the attorneys could just please let me know if everyone who's anticipated is on Zoom, then we can get started. Ms. Neal, do you have everyone here?
I'm waiting for the list from my paralegal.
Got it.
She's not giving that to me yet, so I'm not positive.
Okay. Mr. Clabby, do you have everyone that you need on behalf of the respondent for this hearing?
Believe so, Your Honor.
Okay, thank you, sir.
What the?
And while Ms. Neal is checking, I think we had discussed 20 minutes aside for the hearing. Is that what everyone was anticipating today? Mr. Clabby, Ms. Neal?
Yes,
Your
Your
Honor.
Honor.
Okay, and then thank you all for sending your links over. So I do have those as well. I'm gonna move them closer to me so that I can access them if offered. And have you discussed whether there are any stipulations to any exhibits offered by either the petitioner or the respondent? It'll keep from cutting into your time is why I ask.
No discussion has been had.
Okay, all right. Do you have everyone, Ms. Neal?
Yes, I do. Thank you.
Okay, all right. Let me. All right, everyone ready to go on the record?
Yes, Your Honor.
All right, you ready, Ms. Remy? All right, we are on the record in cause number 401-53890-2025 in the interest of MKM, a child. We are here today by Zoom on respondent's plea to the jurisdiction. If we could please have announcements from everyone who has appeared by Zoom, beginning with the petitioner's attorney and any participants or witnesses on behalf of the petitioner.
My name is Mary Neal. I'm here on behalf of Marcus Solis. My client is here on Zoom, and then we also have witnesses Ashley Jimenez, Marquise Hernandez, Jacob Pakovitz, and Maddie Wickham.
Your Honor, Michael Wasaki and Patrick Clabby here on behalf of the respondent, Brittany Bauman, on your screen as Brittany Molly, and we are present and ready.
All right, and do you have any additional witnesses other than those mentioned, Mr. Wysocki?
I don't believe so, Judge.
Okay.
As the court is aware, the plaintiff bears 100% of the burden with regard to this. It's a situation in which if the court is unsure, or if the court is unclear, or if it's a coin flip, because of that significant burden with regard to the plaintiff, this would obviously then default in favor of the respondent. And so
Okay, thank you for that information, Mr. Wysocki. With that, we had discussed 20 minutes per side. And so at this time, does the petitioner wish to proceed with an opening statement, or would you like to call your first witness?
I'll call my first witness, Your Honor.
All right, let's do this. Ms. Neal, why don't we go ahead and name off the number of witnesses that you do intend to call, and I'm going to swear in each of the witnesses that petitioner intends to call at this time.
There will be 5 of them, Your Honor.
Okay, go ahead.
It'll be Ashley Jimenez, Marquise Hernandez, Jacob Pakovitz, Maddie Wickham, and then my client, Marcus Solis.
All right. All right, and if Mr. Solis, Miss Jimenez, Mr. Hernandez, Mr. Pakovitz, and Miss Wickham would each raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Yes.
I do. Yes.
Okay, thank you. You can put your hand down. Miss Neal, you can proceed with their first witness.
All right, thank you. I'll start with Ashley Jimenez.
Judge, we would invoke the rule.
Okay, Ms. Jimenez, you will be the first witness. Mr. Solis, Mr. Hernandez, Mr. Pakovitz, and Miss Wickham. The rule has been invoked, and so my court coordinator will have to put you in a separate room, so you won't be able to hear the testimony or evidence. You're not able either to discuss anything with each other, so please don't discuss anything, don't review anything new. If you were to do that, that might result in your testimony being stricken. Do each of you understand?
I do.
Yeah.
Yes, I do.
Okay. Ms. Sharkey, if you would put Mr. Solis, Mr. Hernandez, Mr. Pakovitz, and Miss Wickham in the waiting room.
And Mr. Hernandez.
Yes, everyone except Miss Jimenez.
Okay.
All right, that appears consistent with who has been called. All right, Miss Neal, your 20 minutes begins now with Miss Jimenez when you are ready.
Hold on, Your Honor. Mr. Pakovitz is still
It's
here.
okay.
Okay, yeah. Okay. All right, thank you.
Okay.
Ms. Jimenez, how are you currently employed?
I'm employed by High Expectations Hospitality Dallas LLC as an employee.
And are you one of the custodian of records there?
Yes.
Are you familiar with the manner in which its records are created and maintained by virtue of your duties and responsibilities?
Yes, I am.
And did you provide us some documents that are relating to Brittany Bauman's employment with High Expectations Hospitality Dallas?
Yes.
And was there approximately 202 pages that you provided to us?
Yes, there was.
And were these records made at or near the time of each act, event, condition, opinion, or diagnosis set forth? Or is it the regular practice to make these types of records at or near the time of each act?
It's the regular practice at the time of each act.
And is it the regular practice for this type of record to be made by or from information transmitted by persons with knowledge of the matters set forth in them?
Yes, it is.
And is it also the regular practice of the business to keep this type of record in the course of regularly conducted business activity?
Yes, it is.
And is it the regular practice of the business activity to make these records?
Yes.
Your Honor, at this time, I'd like to offer Exhibit P1 into evidence.
All right, any objection to petitioner's Exhibit 1?
May I just briefly take the witness on board, our judge?
Yes, go ahead.
Is this the totality of the records possessed by High Expectations Hospitality in relation to Brittany Bauman?
Yes, it is.
Y'all don't have any additional records?
No, this is everything.
Okay, y'all don't maintain any cameras or anything like that?
We would only do that if there was an incident report or anything that was specific, but we don't record cameras for no reason. We don't save things for no reason. Something would have to happen specifically for us to record something.
No objection to the business records, Judge.
Okay, P1 is admitted.
Thank you. And Ms. Jimenez, based on the records, does it show that Ms. Bauman worked for a club in Dallas from approximately early 2018 to mid 2025?
That's correct, yes.
I will pass the witness.
All right.
And
Any additional cross?
yes, Your Honor. And Ms.
Go.
Jimenez, your records indicate that Ms. Bauman disclosed to you that she was a resident of Illinois, correct?
I haven't, is that in her application? If she did so, then yes.
Yes, ma'am. And in fact, 4929 East River Road, Norridge, Illinois.
Which page are you referring to?
165.
Yep, that was, if this is in her application, then we haven't altered anything.
Okay.
She entered
And-
this.
And it's not uncommon for employees of High Expectations Hospitality Dallas to not be residents of the state, correct?
Correct, yeah.
And sometimes employees with y'all's establishment, that it's actually very common for them to sometimes be here for brief periods and then not, correct?
Correct.
Okay. And in fact, in Miss Bauman's situation, that was also the case with her too, correct? Because sometimes she would work for significant periods and then she wouldn't, right?
Correct. Her activity report shows that sometimes, like in 2018, she only worked 4 days, but she did work a significant amount in 2019. 2020, just maybe 10 days. 2021, only 2 days, and then back again, she was consistent in 2024. So I can't say if she was in the state or not in the state, but her activity shows maybe sometimes she was or wasn't.
Your Honor, really fast, I'm sorry. I just now noticed my client got put into the waiting room.
Okay, respondent, I've paused your time. Ms. Sharkey, could you please pull him back? Mr. Solis, correct?
Correct.
Ms. Sharkey, did we pull him back over? One moment, everyone. Okay. Ready. All right, we're back on the record. Mr. Solis appears to be back with us. Ms. Neal, ready to go?
Yes, yes, thank
Okay.
you.
Mr. Wysocki, when you're ready, sir.
I pass witness.
Okay. Any redirect?
No, Your Honor.
All right. Is Ms. Jimenez excused and free to jump off
Yes, Your Honor.
by the respondent?
Yes, Your Honor.
All right. Ms. Jimenez, thank you for your time. You're free to get off of the Zoom.
Okay,
Petitioner,
thank
you
you.
may call your next witness. Yes, ma'am.
Thank you. I will call Jacob Pakovitz.
Sharkey, if you will make sure Mr. Pakovitz returns. Ms. Neal, when you're ready.
All right, thank you. Jacob, go ahead and remove yourself from on mute.
So,
Hi. Will you please state your name for the record?
Jacob Pakovitz.
And how are you currently employed?
I am the Director of Finance and Information Systems at Hope Fellowship full-time.
And are you familiar with the manner in which records are created and maintained by virtue of your duties and responsibilities?
I am, yes.
And as part of a request, did we send you, or did you send us 2 pages of records that you had?
I did, yes.
And are these original records or exact duplicates of the original records?
These are duplicates of the original records.
And is it the regular practice of Hope Fellowship to make this type of record at or near the time of each act, event, condition, opinion, or diagnosis set forth in the record?
Yes.
And is it the regular practice for Hope Fellowship for this type of record to be made by or from information transmitted by persons with knowledge of the matters set forth in them?
I'm sorry, say that one more time.
Sure. Is it the regular practice of Hope Fellowship for this type of record to be made by or from information transmitted by persons with knowledge of the matters set forth in them?
I wouldn't say it's regular practice, but we do it on occasion.
Okay. And what is the occasion when you do it?
When requested by legal entities for cases like this.
So I understand that the record would be provided in those instances, but you had to have obtained the information in some capacity, correct?
Yes, yes.
And is it normal practice to obtain the information and just keep it
Oh,
within the
yes,
system?
yes, I'm
Okay.
sorry, yes.
And is it the regular practice of Hope Fellowship to keep this type of record in the course of regularly conducted business activity?
Yes,
Is it the regular practice of the business activity to make these kinds of records?
yes.
With that, Your Honor, I'd like to offer P2 into evidence.
Any objections to petitioners 2?
Yes, my only objection is to relevance, Judge.
Okay. Your response?
Your Honor, when I follow up with the following questions about what the records are, you will show, or you will learn that attendance records at Sunday school and Hope Fellowship, which is located in Frisco, Texas, for the child.
Okay. Any further objections from the respondent?
And Judge, it doesn't, they can't, that's all speculation. Unless this gentleman can say that it was for Malik Malley and that he's aware that this was a check-in for Malik Malley, which I don't think he can do. I don't think he has personal knowledge. And so therefore these records would not be relevant unless he can establish that. And it doesn't say it on the records. So
Yes, they do, Your Honor. On the first page, it says below are the attendance records for Malik Malley, date of birth, March 22nd, 2022 at Hope Fellowship.
Okay. Any additional objections?
no objection, Judge.
Okay. Your objection to relevance is overruled. P2 is admitted.
Thank you. Now, Hope Fellowship is located where?
It is located in Frisco, Texas. The location at which these check-ins happened was 9950 Rollator Road in Frisco, Texas.
Okay, thank you. And what is Hope Kids?
Hope Kids is our kids environment during weekend services, which would be equivalent to like a Sunday school service for kids.
Okay. And these records show Malik going fairly often between the end of 2023 through August of 2025.
That is correct, yes.
I'll pass the witness.
All right. Cross-examination,
No questions.
is he free to go?
Yes, Your Honor.
No objection.
All right, Mr. Pokovets, thank you for your time. You are free to go. Petitioner, you may call your next witness.
I will call Maddie Wickham.
All right. Sharkey, if you'll please let Ms. Wickham return. All right, Ms. Neal, you can proceed.
Thank you. Ms. Wickham, please state your name for the record.
My name is Maddie Wickham.
And how are you employed?
I'm sorry, could you please repeat that?
How are you employed?
I'm a partner of Blackfish Intelligence in McKinney, a private investigation firm.
And were you employed to look into some background information on Miss Bauman?
Yes, that's correct.
And what was your understanding of the scope of that investigation?
The scope of the investigation was to run a background investigation, to look into her address history, social security numbers, and other identifying information.
Okay. And so what all did you do to try and locate that information?
So I conducted a background investigation and located her address history and phone numbers, driver's license, social security numbers, and was able to identify a history.
Okay. Were you also able to get information about her vehicle?
Yes, vehicle 2.
Okay. And so based on that investigation, what was the last known address that you found for Miss
I'm
Bauman?
gonna objection hearsay, Judge.
Your response?
Your Honor, this is public information that was able to be found.
Right,
Yeah.
the objection is overruled. You can
Uh,
answer.
Judge, Judge, this is.
Yes, sir.
I'm gonna, Judge, this is blatant hearsay. Like, there's been no exception established. That she is testifying from who knows what. We don't have any underlying quote unquote public record, which also, Judge, as you know, under the rules would be required to be certified for it to not be hearsay. She's quote unquote not an expert. There's no such thing as a PI being an expert, so there's no expert exception. Judge, this is rank. It's not just hearsay, it's rank hearsay.
Right, your objections are noted. I do not find that it is an out-of-court statement. So the objection to hearsay is overruled. She can answer.
So the last address that I located for her was 11116 New Orleans Drive in Frisco, Texas.
What date did that originally show up as one of her addresses?
Judge, permission to take this witness on voir dire. This is.
Yes, you may.
And Ms. Wickham, where did you find this information?
So we use background reporting systems such as through Thomson Routers, which is used by law enforcement, private investigators, the
So
FBI.
you used a computer program.
We use a collection. That's just one example. Additionally, we also use license plate recognition, which
Judge, I renew my objection, Judge. It's rank hearsay.
Right, the objection is still overruled.
Ms. Wickham, what date did you originally see this listed as one of her addresses?
the last date was
Objection,
January
objection,
29th.
Objection hearsay.
Hold on. Sorry. Go ahead, Mr. Wysocki.
Objection hearsay, Judge. It's every single question is going to be here. She's testifying from a computer program. And
Okay, Ms. Wickham, are you testifying from a document, not in evidence? Are you lodging a different objection, Mr. Wysocki.
Yes, it's hearsay and yes, testifying from documents not in evidence.
Okay, your response to testifying from a document not in evidence?
This is information that she gathered, so if anything, it's notes, and so I don't think that it's going to be a document that's not in evidence. It's information that she learned.
She's not an expert. And Judge, just so that we're on the same page, how am I supposed to cross-examine? And she said a compilation of systems such as Thompson routers as an example. How am I, as a lawyer, supposed to cross-examine a compilation of systems such as Thompson routers? I can't do it. There's no way for me to cross-examine this person because they are testifying from rank hearsay.
The objection to that question is sustained. Ask your next question, please.
Thank you. What other addresses have you found for Ms. Baumann?
Objection hearsay, objection testifying from a document not in evidence.
Any additional response?
Your Honor, we did not send this yesterday by noon, but I'd be happy to send it now and offer it into evidence.
I'm sorry, send what?
The report that she has on everything, but again, this is, she's not testifying from the report. And so if that's what the objection is that you would like to see the report, then we can, but she's not testifying from a document not in evidence. She's testifying based on information she's learned, just like any other witness is going to do, including Ms. Baumann, Mr. Solis, any other and anyone else who comes and testifies. They testify based on information that they've learned over the course of their experience in life.
Personal knowledge.
Okay.
Personal knowledge
Ms.
cannot
Neal.
be created. Personal knowledge.
Go ahead and
cannot be
finish, Mr.
created by-
Wysocki.
It cannot be created by a computer program. In other words, Judge, I can't Google Kim M. Lassiter and then read everything on the internet and then say, oh, I have absolute personal knowledge about everything in Kim Lassiter's life and everything she did for these days. That is what is happening here. This person punched my client's name into a computer and now is coming into your courtroom saying, oh, I have personal knowledge. No, she doesn't. She has no personal knowledge. She did a search. She is testifying from a search. That is rank hearsay, and it is testifying from a document not in evidence that would be hearsay. The document would be hearsay. And so no, objection hearsay, objection testifying from a document not in evidence.
I'm going to, these are not statements made outside of court. Like this is just information.
Okay, I understand what you're saying. The last objection was sustained because I heard her say that she found on a report something that she was responding to. So at this time, the objections are sustained. If you'd like to develop further that she's not just reading from a report about whatever compilation or collection has given her knowledge based upon her job and assignment, I'm going to allow you to do that. But to the extent it appears to the court that she's reading from a report that's not in evidence, the objections at this time are sustained. Again, I will give you time to explore further because the court's not aware of how this witness was prepared or what she has reviewed, nor what she's testifying to. Go ahead, Ms. Neal.
Okay. Now, when did you prepare this investigation?
Over the course of the last 2 days.
Okay. And what all did you look at? Do you recall learning the information that you've gathered?
Sorry, could you please repeat that?
What all do you remember looking at to gather the information you have learned?
Do you mean as in address history and social security numbers, or do you mean what I checked?
Yeah, what specifically did you look at to find this information?
I conducted open source intelligence, so we use a number of different options to search this information, all from publicly available records, along with license plate recognition searches, which also include photos of vehicles where they are cited as well from license plate readers and cameras.
And did you take notes over the course of this time?
Yes.
And so based on looking through the information that you investigated over the last 2 days, when were the dates or approximately the first date that you saw that the New Orleans address was affiliated with Ms. Bauman?
Objection, Your Honor, calls for hearsay. Objection, Your Honor, seeks testimony from a document not in evidence. And objection, lack of personal knowledge.
All right, each of those objections is overruled. I do believe that it is not hearsay because it's not an out-of-court statement. Doesn't appear that she's testifying from one particular document. And as it relates to personal knowledge, that objection will go to weight that the court would consider not the admissibility. So those are overruled. You can answer.
Your Honor, may I take this witness on voir dire?
You may.
Ms. Wickham, do you have any personal knowledge yourself as to where, well, actually, I strike that. Ms. Wickham, with regard to the address you're being questioned about, did you derive the testimony you're about to give from a document that you found through doing a search?
I'm not reading off a document if that's what you're asking.
No, ma'am. Did you gain that information from a document you found in a search?
I collected that information from like public resources.
Okay. Did it come off of documents through that search?
It's databases, it's internet searches.
Okay. And you don't maintain those databases, correct?
No, I don't maintain them. They don't run through me.
Those databases are maintained by third parties, correct?
Correct.
And those third parties aren't at court today, to your knowledge, correct?
Correct.
Okay. Judge, I renew my objection. This witness is testifying, and in fact, it's not just hearsay, it's potentially second, third, and fourth hearsay, because we have no idea where these third-party sources got this information from. So she is potentially testifying from third and fourth layer hearsay and from documents that are not in evidence. And Judge, I'm unaware, and I would, as an officer of the court, I would tell you if I was aware of a way. I am unaware of any way possible that there's an exception. This is rank hearsay. She is, again, it's like I said, it's like testifying from a Google search.
Okay. Any additional response from the petitioner?
No, Your Honor.
All right. The objections are overruled. Any additional questions, Ms. Neal?
Yes, Ms. Wickham, what date did you first see shown as a date that the New Orleans address is affiliated with Ms. Bauman?
Judge, I'm going to object. Objection, testifying from a document not in evidence. Judge, I don't have this report. I have no way to cross-examine her. Judge, I'm at a gross disadvantage. Like it literally is handcuffing me as a lawyer. She can make up whatever she wants. I did a Google search and this is what the Google search said, but none of you get a copy of the Google search. And oh, by the way, I'm the end all be all with this. Judge, I can't defend that.
What's your legal objection, Mr. Wysocki?
Objection, testifying from a document not in evidence. Objection, hearsay. Objection, lack of personal knowledge.
The objection to testifying from a document not in evidence to that question is sustained. Ask your next question.
Okay, I'm sorry, Your Honor. I'm getting a little bit confused because the previous question was the same question. You overruled the objection. I've now asked the date about 3 times. 2 of the
I'm
times
happy
you
to
overruled
reply.
the objection to it. And now
Talk over each other. Stop. The last question was, what date did you first see shown as a date
Okay,
that
thank you, Your Honor.
the New Orleans address. That is testifying from something that is not before this court. That objection is sustained. Please do not talk over one another. Again, my court reporter is having a hard time keeping up with multiple voices at once. Please ask your next question. Also, please know that your time is now at 11:48 for the petitioner and 14:17 for the respondent. Go ahead.
The 11116 New Orleans Drive address, when you were gathering the information, what date did you learn was first affiliated with that address and Ms. Baumann?
Objection, hearsay, objection, testifying from a document not in evidence.
Those are overruled.
Ms. Wickham, please answer.
September 11, 2025.
And based on the information that you gathered about this address, is this still her current address?
Judge, objection, hearsay, objection, lack of personal knowledge, objection, testifying from a document not, that she would have no way to know that.
Those are sustained to the way this question was worded.
What was the previous address that you learned based on the information that you gathered?
Objection, hearsay, objection, testifying from a document not in evidence.
Sustained.
Based on the information that you researched to learn about today, what was another Frisco address that you found affiliated with Ms. Baumann?
Objection, hearsay, objection, testifying from a document not in evidence.
Overruled.
Ms. Wickham, you can answer.
There was a Coral Drive Frisco address as well as multiple other addresses in Frisco.
And when you went through the information that you gathered to learn of this, what dates were affiliated with those addresses?
Objection, hearsay, objection, testifying from a document not in evidence. And
Sustained to the way that question was worded. Any additional questions?
I'm sorry, I couldn't hear what your answer was to based on the way it was worded.
I'm sorry. What?
they didn't
On
hear
my
your
end,
answer.
all I heard you say was based on the way that was
Sustain-
worded.
It was
Okay.
sustained. Yes, ma'am.
Through the information that you gathered to learn about the addresses that where Ms. Baumann was affiliated with, you stated there was a Coral Drive and a couple of other Frisco addresses. Is that correct?
Yes, that's correct.
Objection, hearsay, objection, testifying from a document not in evidence, objection, leading.
Sustained us to leading.
I'm sorry, I don't fully understand how that was leading when it was just reiterating what she just stated. I'm sorry, this is. Is my time being eaten up by every single objection that he's making? I just want to make sure I understand that.
No, ma'am. I
Okay.
pause your time each time that an objection is made or that the respondent has asked to take the witness on voir dire.
And Judge,
Thank
I
you.
would just like a running objection to this witness as to hearsay testifying from a
That's-
document not in evidence, because I don't want, she could eat up my entire time with a witness who literally has no personal knowledge with regard to this case.
I can't give you a running objection, Mr. Wysocki, because some of the questions, the way that they're being asked, obviously I have sustained based upon the way that they're being asked or answered, and some I have not. So you'll have to still object at the time.
And Judge, just so we're all clear, I think the confusion here is a private investigator is a fact witness. A private investigator can only testify with regard to facts. They can't testify about stuff they found on searches. That's hearsay. And I think that would clear all this up real fast if everyone just understood. This is a fact witness. It would be just like as if I call my client or if I call some person off the street. They are a fact witness, Judge. And fact witnesses can't testify to stuff they found on the internet. So I'm happy to keep going.
Mr. Wysocki, do you disagree that an investigator hired for the purpose of investigation could absolutely be an expert witness and be able to investigate, which is what lawyers do all the time?
They get to testify about what they observed. So yes, so like if she saw my client at a restaurant, or if she saw my client, she'd say, yes, I observed her on this day at this time and this. And then I did I did a search, and I found, that I thought she might be at this address. So I went there and I found her. But what she can't do is say, I did a people map, is essentially what she's done, Judge, is what we call it in family law. We do them on essentially every opposing party. And she's done a people map, and she's testifying to you from her people map. Essentially, you call it a people map or a background check. Judge, that's hearsay. It's not admissible.
Okay, I hear what you were saying, but what I have heard from the investigator is there are license plate searches and there are a number of things that hold on, please don't interrupt, that she has done in her capacity as an investigator. So in her capacity as an investigator, she does not have to personally see the license plate. She can collect those items and offer an opinion based upon her job as an investigator. I understand your objections. And again, those would go to the weight that the court would give her testimony, but not the admissibility of the testimony, unless she's saying, I saw on this one thing, this item or what have you. But I still have not heard any out-of-court statements offered for the truth. A statement is still a statement made. So your objections are on the record and they are noted.
I understand the disconnect, Your Honor. She's not a police officer and she's not a CPS investigator. She's a private investigator. And so I understand the court's distinction now. Police officers for sure can testify from, for instance, public records that they pulled, et cetera, et cetera. She's not a police officer. She's not a sheriff. She's not a public servant. She doesn't fall into those categories. She is a PI. And so I think that's where we have a disconnect, Judge.
All right. And I've paused both of your time. I want you to both fully be heard, and I'm not taking up any additional time. Ms. Neal, do you wish to be heard any more on this line of questioning, and what the court has now put on the record as to my reasonings for sustaining portions of this testimony and overruling others? I want to
No,
give
Your
you the
Honor.
opportunity free of taking up any of your time. You don't wish to
No,
put anything on the record as to the respondent's objections?
I appreciate it, but I believe that Your Honor has taken painstakingly efforts to explain the rulings that you've made, and I don't believe we need to continue going into them.
I am attempting to, but I just want you both to know that the reason that I'm asking for both of you to be heard right now, outside of your 20 minutes, is if there is additional argument, I don't want to take up your time. I want to hear it now. And I want to be sure that the court is aware of all of the arguments and responses from each side so that you can complete putting on your case in chief. So there's nothing else that you wish to put on the record?
No, I believe I've covered everything I would say again.
Okay, all right. And we're at 10:41 remaining for petitioner and 14:10 remaining for respondent. Ms. Neal, when you're ready.
Thank you, Your Honor. Now, Ms. Wickham, based on the information that you collected about the Coral Drive Frisco address, what date was the last date that Ms. Baumann was affiliated with that address?
Objection hearsay, objection testifying from a document, not in evidence.
Those will be overruled.
You may answer, Ms. Wickham.
Her vehicle was last sighted there on January 29, 2026, so just a couple of days ago. And it had frequently been seen at that address dating back to last year.
Did you find any addresses for Ms. Bauman when you collected this information that was outside of the state of Texas?
Yes,
Objection.
I did.
Calls for hearsay. Objection. Testifying from a document not in evidence.
Sustained to the way that question was asked.
Based on the collection of information that you gathered about addresses affiliated with Ms. Bauman, were any addresses listed for Ms. Bauman outside of the state of Texas?
Yes.
And what other states did you find, or based on the information that was collected, what other states have addresses affiliated with Ms. Bauman?
Objection. Hearsay. Objection. Testifying from a hearsay document.
Overruled.
You may answer, Ms. Wickham.
There are other states such as Illinois.
Any other states?
Yes, there was one other state, Michigan, I believe.
Okay. And based on the information that you collected about these addresses, did any of them overlap with dates that were also affiliated with addresses in the state of Texas?
As a general overlook, some of them overlapped. However, once I dug deeper into the dates and
Objection.
specifically,
Non-responsive after they overlapped.
Sustained.
And as you were collecting information about the addresses and her license plates and the social security numbers, did you gather an opinion about why these addresses would overlap?
Objection. Speculation.
Overruled. She can testify as to her opinion based upon her research and collection.
yes, I did gather an opinion.
And what is that opinion?
Objection. Speculation.
That's overruled.
Ms. Wickham, you can answer.
The addresses can occasionally overlap if you don't update your address on certain identifying records. However, I am able to see.
Objection. Non-responsive at this point.
Sustained, beginning with however.
However, I'm able to see.
Objection.
Ma'am,
Sorry,
hold on.
Ms. Wickham.
Hold on.
Oh,
Yeah,
sorry.
hold on. Please ask your next question.
Yeah, thank you. You also stated that you looked into her license plate recognition, is that correct?
Correct.
And based on the information that you collected based on the license plate recognition, where did you find Ms. Bauman's vehicle?
In Texas.
And what approximate dates did you find it in Texas?
Objection. Hearsay.
Overruled.
You may answer, Ms. Wickham.
I found it on an almost monthly basis dating back until November 1st of 2024.
You also looked into, I believe you stated, her social security numbers.
Correct.
Based on the information that you collected, based on her social security numbers affiliated with Ms. Bauman, did you find anything unusual?
Yes, I did. I found multiple social security numbers tied to her name.
And what does that typically indicate?
It typically indicates misuse of multiple social security numbers, potential fraud.
I'll pass the witness.
Cross-examination.
Just briefly, Ms. Wickham, do you have any personal knowledge as to where my client physically resides? Have you witnessed her at a residence?
No, I have not.
Okay. Have you witnessed her driving a car anywhere in this state?
I have not personally, but I have through the license.
And so objection, non-responsive after I have not personally.
Sustained.
And in fact, your entire testimony here today was based on documents you've read off of either a computer screen or printouts, correct?
Of a computer screen, yes.
Okay, I'll pass the witness.
All right. Any redirect?
No, Your Honor.
Is she free to go?
Yes, Your Honor.
No objection.
All right, Ms. Wickham, thank you. You're free to go.
Thank you.
Petitioner, you can call your next witness.
Marquise Hernandez.
All right, and Ms. Neal, 734.
Okay, thank you.
When you're ready.
All right, Marquise, can you please take yourself off mute?
Hello,
Hi, will you please state your name for the record?
Marquise Hernandez.
And how are you affiliated with Marcus and Miss Bauman?
Um, I've been Marcus's close friend since birth, pretty much, and I've known Miss Bauman in middle school.
Okay. And where do you currently reside?
I currently reside in Dallas, Texas.
And how long have you been here?
In Dallas, since 2019.
Okay. Have you ever interacted with Marcus and Miss Bauman in the state of Texas?
Yes,
Do you know approximately when the first time you would have interacted with them in the state of Texas was?
together. 2024. It was a little beginning of the year and close to the end of the year. We're yeah, around.
Have you ever interacted with Miss Bauman when Marcus was not there?
Yes.
And when was the last time that would have occurred?
It was Easter 2025
And where did you see her?
at my friend's house in Oak Cliff, in Dallas.
Okay. Did you have a conversation with her?
Did I have a conversation with her?
With Miss Bauman at that time?
Yes.
What was the topic of conversation with Miss Bauman?
It was really light. It's about how she was settling in Dallas. Just her new ventures and what was going on. I didn't really ask about the relationship with Marcus because at that point, I knew that they were going through some things. So we were around people. So I just try to, have small talk.
And based on the conversation you had about her settling in Dallas, did she give you any indication that she was not living in the Dallas area?
No,
In fact, did she actually answer questions about what life was like in Dallas?
Yeah.
Do you recall anything that she said about her life in Dallas at that time?
no, just about how much, people have more money there.
Non-responsive after no, Judge.
Sustained as to non-responsive.
Okay. So you started to give a different answer. Did she give any indication about what it was like living in the Dallas area?
Objection asked and answered, Your Honor. His answer was no.
Okay.
Hold on, sorry. Sustained as to asked and answered.
Did she talk about working in the Dallas area?
Yes.
Do you recall what she said about working in the Dallas area?
Really just, her new friends that she was working with.
Okay. Were either of her children at this Easter event that you saw her at?
The Malik was the boy. Yes.
Okay. And again, this was Easter 2025. Do you recall if that was so it was an Easter event in 2025?
Yes, it was an Easter event. I don't believe it was right on Easter, but it was an Easter event. I mean, my kids were there. We were all cracking eggs.
Okay, I'll pass the witness.
Right. Cross-examination.
You also talk to Mr. Solis fairly often, correct?
Yeah.
In fact, he's actually your cousin.
We call each other cousins, but we're not related by blood.
Okay. So if Mr. Solis communicated to Ms. Bauman in early November 2024 and said, I would have moved down there and stayed with Marcus, shit. That's referring to you, right, Marquise? Marquise?
Marquise, yes, not pronounced Marcus.
Okay, did Mr. Solis talk to you about moving in with you?
No.
Okay, and why would he be texting Miss Molly about moving in with her if he already lived here?
Objection calls for speculation.
Sustained.
Okay. Were you aware that he testified to this court that he lived in Texas with Miss Bauman through early 2025?
I mean, that might be the case. I wasn't aware. I mean,
Okay,
and
well, you're his cousin, right? You just said we call each other cousins, right?
right.
Do you think you would know if he lived in Texas through early 2025?
Yeah.
Yeah, and you didn't know?
I mean, we didn't talk in the beginning of the year. I was going through some things, so, but yeah,
Oh, okay,
correct.
okay. Pass the witness.
All right. Any redirect?
Yes, Your Honor. Marquise, do you know where Marcus has lived for every month of his life?
No.
I'll pass the witness.
But
Any
you would-
recross?
Yes, Your Honor, but you'd know if he lived in your town though, right? Y'all are boys.
Right, right, and that's he was making that move in 2024. So at the end of 2024, I was assuming that he was living in Dallas, and then the start of the year happened. I had my own issues, my own troubles, and I found out that he wasn't there in April. So
Okay, okay. I'll pass the witness.
Anything
No
further?
questions, Your Honor. No, thank you.
All right. Is he free to go?
Yes, Your Honor.
Mr. Wysocki, is Mr. Hernandez free
No
to go?
objection, Judge. I apologize. No objection.
That's okay. Mr. Hernandez, you're free to sign off. Thank you.
great,
Do y'all
thank
want
you.
a time check again?
Yes, please.
4:11 and 11:12.
Okay.
Petitioner, you can call your next witness.
I'll call Marcus Solis.
All right. Mr. Solis, can you unmute yourself, please, and turn on your camera?
Am I unmuted?
You're unmuted, sir, but you have to turn your camera on as well.
I'm trying to turn it on. Um, hello? Hello?
All
Yeah,
right.
hold on.
Thank you. Ms. Neal, when you're ready.
All right, thank you. Marcus, when was the last time that you saw Miss Bauman in the state of Texas?
January 1st, she dropped me off at the airport.
And at that time, where was she residing?
The Alexandria address in Frisco.
Uh, when you left in January of 2025, did she have any discussion with you about leaving the state of Texas?
No.
And did you ever interact with any of her social media accounts thereafter?
Yeah.
Which social media account did she have that you saw?
Instagram and Snapchat.
And you recorded some of her videos that she took, is that correct?
Correct.
And she posted onto her Instagram?
Correct.
Your Honor, I'd like to offer, I'm sorry, before that, the recording that you took, was that a true and accurate depiction of what you saw at the time that you took the recording?
Yes.
And it was specifically recording of a video that Ms. Baumann had produced onto her Insta, is that correct?
Yes.
Your Honor, I'd like to offer Exhibit P4 into evidence.
Any objections to petitioners 4?
Yes, Your Honor. Objection, improper authentication. And if the court needs me to explain, I can, but
Apologies, I'm just pulling it up. Hold on.
no problem.
Okay, that objection is sustained. I'm looking at 4 and it appears to be some text messages, but I've heard something
Oh.
about a video. So the objection is sustained.
I'm sorry, it's P5.
And I'm happy to respond, Judge.
Go ahead. Any objections to petitioners 5 then?
Objection, improper authentication, Judge. There's no testimony necessary for authentication. He didn't testify that he made this video. He didn't testify that this video was, on and on and on and on. And so, objection, improper authentication.
Okay, and because we're on Zoom, this might be my problem and not the parties, but I'm looking at P5.
Okay, I'm sorry. Yeah, it was P4 that I was originally.
It was P4?
Yes.
Can the video, you've listed it as video from Easter 2025.
Yes. If you see
Okay.
at the very top left corner, it has her Instagram handle.
Okay, again, because we're on Zoom, Ms. Neal, will you just lay some additional predicate as it relates to the video so that the video that you're offering can be linked to the testimony, please? So the objection is still sustained, but you're going to have to tie it since we're by Zoom.
Okay, I'm going to move on, Your Honor.
Okay.
You also took a screenshot of a Snapchat that she took inside of a home. Is that correct, Mr. Solis?
Yes.
And the photo that you took of the photo, was it a true and accurate depiction of what you saw at the time that you saw the photo?
Yes.
Your Honor, I'd like to offer P6 in the evidence.
All right, any objections to P6?
No objection, Judge.
P6 is admitted.
And what was significant about the photo as to why you took a photo at that time?
Because she was recording a Snapchat and I could see the background of the house.
And did you recognize the background of the house?
Yes.
What house was it?
The Alexandria Drive address.
And when approximately was this posted to one of her social media accounts?
Like July or August of 2025.
Now, you had to employ counsel to address this subject matter jurisdiction, is that correct?
Yes.
Your Honor, I'd like to offer P8 and P9 into evidence with relation to my attorney's fee statements and a summary of fees.
All right. Any objection to P8 or P9?
No objection to P9 as a summary. No objection to P8.
P9 is admitted as a summary and P8 is admitted.
Thank you. Now, Marcus, just from your personal experience with Miss Bauman, when did she first move into Texas?
She moved to Texas in July of 2024.
And you visited her in Texas?
Yes, frequently.
Did you ever consider yourself to be living in Texas?
That was the original plan, to move to Texas.
But at any point during the visit, did you actually ever consider yourself to be living in Texas?
No,
Okay. And as of January 1, 2025, she was still living in Texas because she would have dropped you off at the airport. Is that correct?
correct.
I'll pass the witness.
Cross-examination?
Yes, I'm going to call the witness's attention to Exhibit 2. Your Honor, I believe, is share screen available?
Let me give you that. I've paused your time.
Your Honor, if you could have
I'm
me
trying
give me the permission to share, I can share while Mr. Wysocki conducts
Perfect.
the
Is that
examination.
okay? Miss Sharkey, I believe she is still the host, so I might need her to do that.
Oh, I think she changed you to host, Judge.
I found a button and I
Oh.
made myself the host. So give me a second, guys. Allow all participants to share screen. Mr. Clabby, will you see if you have that availability now?
Host disabled participant screen sharing.
Try again, please.
Okay.
All
Okay.
right, when you're ready, Mr. Wysocki.
Yes, Your Honor. Mr. Solis, do you see the image on the screen there? The text message?
Yes,
Isn't it true you sent that text message to Ms. Bauman on November 11th, 2024?
I don't recall the date, but yes, I sent the text message.
I offer mothers 2, Your Honor.
Any
No
objection to mothers two?
No objection.
Mothers two is admitted.
If you lived in Texas, as you testified to this court at the last hearing, you told Judge Lassiter that you lived with Miss Bauman through January of 2025. Then why here did you text her saying that I would been moved down there and stayed at Marquis shit?
What is the question?
Okay. If your prior testimony was true,
hmm
then why would you have sent this text message in November?
Well, when I first went down there in July with her, I was there for a full month, and then I bought everything for the house, so I was considered moving. I was going to move down there. I was basically going down there once every month, every 2 weeks, as often as I could, until I could fully move down there. And then all this happened.
Okay,
And
let's keep going. I'm gonna pull up respondents 14. Mr. Solis, do you recognize respondents 14 as a text communication between yourself and Miss Molly from November of 2024?
yes,
I offer respondents 14.
Any objection to mothers 14?
No.
Okay.
Mr.
Mother respondents 14 is admitted.
Mr. Solis, you actually just testified to this court that Miss Molly was living in Texas through January of 2025. However, in this text, you say, I went to your house and seen boxes. I was hurt, correct?
Yeah, I believe we were talking about a previous time though,
In
because this,
November 2024, just like her affidavit,
yeah, because
just like all her stuff.
Hold on. Hold on, Mr. Solis, please don't talk over
I'm
the
sorry.
attorney. Let him finish his question and then you can answer. Go ahead.
Okay, isn't it true you're hurt? You were hurt here because she didn't live in Texas anymore.
No, that's not true.
Okay, you said you up and leave quick, right?
Yes.
Okay,
That's when she was leaving from the Memphis address to the Alexandria address.
with regard to Your Honor, I'll call the witness's attention to respondents 15. Do you recognize respondents 15?
Yes.
Text message you sent in December 2024.
Mm-hmm.
I offer respondents 15.
Any objection to mother respondents 15?
No, Your Honor.
Okay,
Mother respondents 15 is admitted.
okay. Mr. Solis, based on respondents 15, would you like to recant any of your prior testimony to this court?
No, everything that I'm saying is true to my knowledge,
So
and I
when you
believe.
said here, we've been living apart for 6 months now, do you
Yeah, in
agree or
different sorry.
objection? Do you agree or disagree that that contradicts all of your prior testimony to this court?
We were living apart in separate households.
Okay.
And she was still in
I'm
Texas
gonna
at the time of that text.
call the witness's attention to respondents 22. Mr. Solis, does respondents 22 fairly and accurately depict the subject matter therein?
I'm sorry. What was the question?
You're familiar with this photo, correct?
Correct.
And it's an accurate photo?
Correct.
And this is you and your friends?
Correct.
I offer respondents 22.
Any
What is it? What
objection?
is what?
Yes, objection relevance, Your Honor. I don't see how this has to do with where Ms. Baumann was living from the 6 months prior to June 30, 2025.
Happy to respond, Judge.
Go ahead.
Texas Supreme Court credibility of witness is always relevant.
All right. The objection is overruled. Respondents 22 is admitted.
Mr. Solis, I'm going to call your attention to respondents 23. Does this photo fairly and accurately depict the subject matter contained therein?
Yes.
Okay. In fact, you took that photo, correct?
Correct.
And this photo was, when was this photo from?
Maybe like 3-4 years ago.
Okay. And was this a gang-related incident?
No.
Okay. How did your face get injured?
Got robbed by like 5 masked men leaving urban air.
Okay. Did you have children with you?
Yes.
Okay. I offer respondents 23.
Any objection to respondents 23?
I'm going to object as to relevance and object to as prejudicial.
All right. The objection to relevance on respondents 23 is sustained. It's not admitted.
Judge, I'll pass the witness at this time.
All right. A minute 34, Ms. Neal.
I will reserve my time.
Okay.
No questions.
Do you have any additional witnesses or evidence?
No, Your Honor.
Okay. Do you rest?
Yes, Your Honor.
All right. I do find at this time that the petitioner has carried their burden. Does the respondent wish to use your remaining time to put on any testimony or additional evidence before argument?
Yes, Your Honor.
Okay. When you're ready, do you wish to make an opening statement or call a witness?
I call my client.
All right. Okay. Is your last name Molly, ma'am?
Yes,
All right. I don't believe we swore you in at the beginning. Is that correct?
correct.
All right. If you'll raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Okay, you can put your hand down. 604 remaining, Mr. Wysocki. When you are ready, you may proceed.
With regard to the matter before the court, will you please state your name?
Brittany Ann Malley,
And Miss Malley, where is your present residence?
in Tinley Park, Illinois.
Okay. And with regard to Texas, was there a period in 2024 in which you briefly resided in Texas?
What was the question?
Was there a brief period in 2024 where you were in Texas?
Brief, yes.
Okay. What were the circumstances surrounding that?
My daughter was in school and me and my husband at the time were separated, so I was there with my grandmother.
Okay. Did that separation end?
Yes, we are now back together.
Okay. And did you return to Illinois at some point in 2024?
Yes.
Okay. When was that?
I recall either December 2024 or January 2025, early January.
Okay. Do you recall that text that showed that you had packed up and left in November of 2024?
Yes.
Okay. Does that help refresh your recollection?
Yes.
Okay. With regard to the circumstance, were there times that you were back in Texas periodically for any reason?
I would visit while my daughter was still in school, yes.
Okay. Did y'all yank her out of school in the middle of the semester?
No,
Why not?
because we wanted things to remain as stable as possible for her.
But in that time frame, was the child the subject matter of this case in Illinois?
Yes.
Okay. And you've provided this court records. I would offer those as respondents 26.
All right. Any objection to respondents 26?
I do not have a 26.
Are you able to show us that one, please?
Yes, Your Honor.
Thank you.
And these have been on file, Judge, since January 20th. Yeah.
All right. Any objection to respondents 26?
Yes, Your Honor, while the business records affidavit has been on file for the requisite 14 days, the actual records were not provided 14 days in advance. And so therefore, I do not believe that they have carried the requirement under the business records affidavit rule.
Oh, good. We filed and provided all the above.
Not 14 days in advance.
One moment, please. I know the rule changed just a few years ago. Mr. Wysocki, for the record, do you have the date that the records themselves were also provided?
My understanding, Judge, is we provided everything the same day.
Any additional response, Ms. Neal? Do you have?
Yes, Your Honor. So they filed this on that Tuesday. And when we did not receive the documents, we had to send a follow-up request. And so that we did not receive them until January 23rd, 2026.
But I'm happy to respond if the court needs me to.
Go ahead, Mr. Wysocki.
As I sit
That
here right
would-
now, as I sit here right now, I'm not going to argue with an officer of the court. My understanding was we sent it. She says we didn't, but I don't think that affects the indicia of reliability, which is what this rule is about. And I don't think that affects the indicia of reliability with regard to these records, Judge. And I would reoffer Exhibit 26.
All right, looking at 902, 10A, large A, it does show that both the affidavit and accompanying records must be served at least 14 days prior. So based on what the court has before me, respondents 26 is not admitted.
Hey, Patrick, can you jump off the screen and see if Jesus knows whether or not what the status of that is? Whether or not we filed the records?
Will do.
Miss Molly, what is Bright Scholars Clubhouse?
That is Malik's daycare in Illinois.
Okay, and was Malik enrolled in that daycare in December of 2024?
We applied, we got approved January 2025.
Okay. And the enrollment was December 22nd, 2024?
I do not know the date 100%. I would have to check.
Okay. Do you recall filling out the paperwork in December of 2024?
Yes.
And was the child attending daycare there?
Yes.
Okay. With regard to the child, I'm going to call your attention to exhibits 15, 16, 17, and 18. Are those certified records with regard to, I'm sorry, 16, 17, and 18. Are those certified records with regard to this child's birth and public records related to his residence? Ms. Molly, you can answer the question.
I thought they were going to show the documents.
No, we had previously sent them to you. So these are the birth
Yes.
certificate, social security card, and a passport.
Yes.
Okay, I'd offer 16, 17, I'm sorry, 16, 17, 18, Your Honor.
Any objection to mother respondents 16, 17, or 18?
No, Your Honor.
Okay, 16, 17, and 18 are all admitted, and I know the parties are becoming stressed about time. So petitioner, you have 134, respondent, you have 142. I'm adding 3 minutes at this point for both of you. I want you to be able to complete your questioning, but I also want you to be able to argue based upon the evidence. So I've added 3 minutes to each of you. When you're ready, Mr. Wysocki.
With regard to Mr. Solis, did he at any point live with you in Texas?
No,
If he testified that to this court, is that accurate?
no,
Okay. Um, was Texas ever the home state for your child? For your son?
Objection calls for a legal conclusion.
Sustained.
Did the child reside here at any point for 6 months continuously?
no,
With regard to the child, I'm going to call your attention to that exhibit 3, where Mr. Solis do you recognize this exhibit?
yes,
Is this a text between yourself and Mr. Solis?
yes,
Is this from August of 2024?
yes.
And what is it that you told Mr. Solis he needed to do in August of 2024?
Objection
To leave.
hearsay.
Sustained at this point.
I'd offer respondents 3, Your Honor.
Any objection to respondents 3?
Yes, Your Honor, to hearsay.
Text between the parties, she proved it up.
Okay. The objection to hearsay is overruled. Respondent mother's 3 is admitted.
Your Honor, may I respond briefly?
Yes.
On the hearsay. I agree that my client as a party opponent, there's a hearsay exception, but this is clearly a primary text message from Ms. Baumann, who there is no hearsay exception. Just because she is a party does not mean we get to accept the hearsay. It's only a party opponent, which she is not in this regard.
Mr. Wysocki?
Judge, it's non-hearsay because she could testify as to the accuracy of her statements. And then his is not hearsay because he is a party opponent. She is correct. That's why I don't need him and her to prove it up. I only need one of them.
Okay, the court would be unable to read father petitioner's statements without context. I understand what you're saying, that the court cannot take for the truth of the matter asserted the statements that Miss Molly made herself, but I need what she said to create context for the response by Mr. Solis. So the statements by Mr. Solis, I do not find are hearsay, and the other statements I do not take for the truth of the matter asserted, but respondents 3 is still admitted. Go ahead.
With regard to Mr. Solis, are you concerned with regard to his motivations on this case?
Objection
Yes.
relevant.
What's the relevance, Mr. Wysocki?
Again, Your Honor, credibility of Mr. Solis is always relevant. He's provided this court now multiple layers of inconsistent testimony, but I believe this will go to show the court the basis behind his motives.
Your Honor,
Okay,
but it
I
does
don't,
not go to subject matter jurisdiction.
right. The objection is sustained at this time.
Okay. Has Mr. Solis threatened you?
Objection
Yes.
relevant.
What was your objection? Sorry, cut off.
Relevance and objection leading.
Sustained as to relevance and as to leading at this time.
I'm going to call your attention to Mother's Exhibit 11. Do you recognize Mother's 11?
Yes.
Is this a true and accurate text between yourself and Mr. Solis from December of 2024?
Yes.
I'd offer Mother's 11.
Any objection to mother or respondents 11?
Yes, Your Honor, I'd object as to relevance. I don't see how this has anything to do with where someone lived the 6 months prior to June 30, 2025. And objection as to hearsay.
Any response from the respondent?
Yes, Your Honor, this text contradicts his testimony concerning his relationship with the mother before this court. And it also contradicts his testimony concerning the nature of the residence, because he claimed he was quote unquote living with her as of that time as well. It also contradicts statements where he references his knowledge and what he knew because of the status of that relationship, Your Honor. So
There's nothing inside of this that has anything to do with anything other than them trying to be prejudicial and sway this court to already start looking badly upon my client.
The objection to relevance is sustained. Respondent mother's 11 is not admitted.
I'll call the witness's attention to respondents 5. Miss Molly, do you recognize respondents 5?
Yes.
They fairly and accurately represent texts from Mr. Solis in January of 2025.
Yes.
Have you altered that in any way?
No.
I'd offer respondents 5, Your Honor.
Any objection to respondents 5?
Yes, Your Honor, relevant. There's nothing in here that relates to where anybody was living prior for the 6 months prior to June 30, 2025.
Happy to respond, Judge.
Go ahead.
He says clearly right there that he has not even seen the child since December 18th. So how would he know where the child was living if he hasn't even seen the child?
Okay, the objection to respondents 5 is overruled and respondents 5 is admitted.
Do you see here, Miss Molly, where Mr. Solis says he hasn't even seen the child since December 18th?
Yes.
Okay, and this is a text from late January 2025?
Correct.
Did you hear how he had testified earlier, though, that he had seen you and the child and et cetera in January and all that?
Yes.
Okay, or do you dispute his testimony that he gave the court earlier regarding having seen the child in January of 2025?
Yes.
Okay, were you residing in Texas in January of 2025?
No.
Were you residing in Texas at any point in 2025?
No.
Have you seen anything here today evidencing you living here during that time frame?
No.
So let's talk about some of the records they had. Up until approximately November of 2024, your work records that they admitted showed you working almost every day up until November, December of 2024. Okay. After that, does it clearly show that your going there was very sporadic?
Yes.
Okay. And additionally, with regard to those church records, again, up and through November, December 2024, does it show that you were going to church 3, 4+ times a month?
Yes.
And then after that, does it show that at most you would go once or twice a month?
Yes.
Is that consistent with your testimony to this court that after that time, you were coming down here to check on your daughter until her semester ended?
Correct.
Okay. I'm sorry, her school year ended.
Yes.
And
All right,
at
and
the-
Mr. Wysocki, that's your time. I've added another minute for each of you, but you're now down to 49 seconds to finish this witness to allow for cross-examination.
and Miss Molly, are you presently married?
Yes.
Okay. Where do you and your husband reside?
In Illinois.
Okay. And has the child resided in Illinois during that time frame?
Yes.
Okay. I pass the witness, Your Honor.
All right, 25 seconds remaining, and petitioner, with the additional minute, you have 5 minutes and 34 seconds. Go ahead.
Thank you, Your Honor. Ms. Foreman, at the Bright House daycare, you're saying that Malik is going to in Illinois. Do you have to do a check-in and check-out there?
Yes.
You stated that you are currently married. Is that a legal marriage or ceremony only?
Can you explain? What is
Do you have-
ceremony?
Do you have a marriage license?
Yes.
From what state?
I'm from Palestine.
And when was that marriage, or what date is listed on that marriage license as when you got married?
That's June of 2020.
Were you given an opportunity to review the text messages that, or the exhibits that we provided yesterday?
Yes.
Okay. Do you recall seeing a text message in there that listed you as one of the communicators?
I seen a text message with my name stored. I did not see the number, no.
Okay. Did you recognize that communication between you and Marcus?
I did not.
Okay. Has there ever been domestic violence between you and your husband?
Domestic violence with me and my husband?
Correct.
No.
He was never arrested for domestic violence against you?
Hey,
Against
Judge,
me, no.
hold on. I'm gonna object relevance at this time. If I couldn't get in Mr. Solis beating the heck out of Miss Molly, then I object relevance.
Okay, your response, Ms. Neal?
Yes, Your Honor. The text message that we are going to ultimately be showing that I'm going to get through Mr. Solis, I believe, is an incident of her potentially lying to a court, and so it goes to credibility.
You're gonna have to give me a little more, Miss Neal, because the question I think was related to domestic violence between her and her husband. So just give me a little more context, because I understand you're saying it goes to credibility, but I'm not sure that question is going to get there.
I understand. Yeah. So I guess I'm more just laying the foundation of trying to understand the circumstances behind a text message where she told Mr. Solis that she lied to a court about a domestic violence charge. Okay. I'm sorry, Your Honor. I can't hear anything right now, so I didn't hear anything you just said. Can you hear me?
Yeah, I could hear.
Yeah.
I can hear you. I'm gonna run in the courtroom and see what's happening.
Bobbin, would you mind talking? Just make sure I can still hear you.
I'll be right back. I'm gonna run in the courtroom.
I can't hear anything anymore.
Can you hear me?
I can hear you.
You can hear me?
I can.
Okay, hang on. Okay. Judd, I keep freezing. Okay, can you hear me?
Yes.
She's having to shut down everything in the courtroom. This happened once before, so it just takes a minute. She has to shut everything down, restart everything, reopen everything, so it takes a few minutes. But she wanted me to let you know, petitioner has 4 minutes, 2 seconds. Respondent has 25 seconds.
Thank you, Tammy.
Mhm.
We're not on the record, but is everyone still here?
Yes,
Yep.
Judge.
Thank you. Sorry, guys. Right around 2 hours when this has been on, my sound cuts out, and it's done it twice during a jury trial. So that's fun. Let me get your time back up. I think I gave it to Miss Sharkey, but now I don't have it. Miss Sharkey, it was 4 something and then 25 seconds or 20 something seconds.
It's 4 minutes, 2 seconds for petitioner and 25 seconds for respondent.
Okay. Y'all give me a minute. All right, you ready? All right, we are back on the record after a Zoom malfunction that was on the part of the court. The reporter and I were able to hear everything up to a certain point, and then everything cut out. So before we begin, petitioner, is your client still on, and do we have everyone that we need?
Yes, Your Honor.
All right, and respondent mother, is your client still on, and do we have everyone that we need that should be on?
Yes, Your Honor.
Okay, thank you. Then with that, we are on cross-examination by Ms. Neal. So Ms. Neal, you can proceed when you're ready. And the
And,
witness
Your
is
Honor-
still under oath. Sorry, go ahead.
That's okay, Your Honor. You cut out as you were giving a ruling on the relevance, I believe, objection. And that's what I did not hear.
The last objection was overruled.
Okay, thank you, Your Honor. Is it possible to read the question back into evidence for Ms. Baumann to answer?
Are you able to do that?
Can you hear me? Can y'all hear me?
Yes.
Last question was, he was never arrested for domestic violence against you. Answer, against me, no.
Okay, thank you. Ms. Baumann, can you remove yourself from mute?
Yes.
Okay, thank you. Now, do you recall taking Marcus to the airport in January 2025?
I do not recall the date, no.
Do you recall taking him to the airport at the end of his visit to Texas when he was there in December of 2024?
I don't recall.
Do you recall sending him text messages asking him to leave early?
For what date?
And when he was there in December of 2024?
I don't recall.
Do you recall being in the state of Texas in December of 2024?
Shortly, yes.
And what dates were you there?
Again, I cannot recall the specific date.
Do you recall being in Texas in January 2025?
What date?
Just in the months, you recall being there in the state of Texas in January 2025?
I probably was. I don't recall the exact date.
And how long would you come down for each month?
I would try to come every couple weeks.
And for how long?
It would change.
Okay, what was the longest amount of time that you spent in Texas in 2025?
I don't recall.
What was the shortest amount of time that you spent in Texas in 2025?
I don't recall.
I'll pass the witness.
All right,
Um,
25 seconds for any redirect.
I'm going to call the witness's attention right now to rebuttal exhibits 2 through 7. Ms. Molly, we sent you rebuttal exhibits 2 through 7. Do those fairly and accurately depict the subject matter contained therein?
Yes.
Have you altered those in any way?
No.
I offer rebuttal exhibits 2 through 7.
We have 2 as an exhibit that has been admitted. Do you have a different 2 or is it the same one, Mr. Wysocki?
These are different. I don't know why they did them this way. We can
Would you just
renumber
give it a
them.
new, yeah, will you just
can
give that
renumber
one a
them for
new
the-
number?
We can renumber them for the court. And in fact, I'll just make the entire bundle, the 1, 2, 3, the 5, the 6 images. I'll make that exhibit 27.
Okay.
Do you recognize those photos in exhibit 27 as true and accurate, Ms. Molly?
Yes.
Have you altered those in any way?
No.
I offer exhibit 27, Judge.
All right, any objection to respondent mother's 27?
I don't know. I've not seen these before, and I'm unable to see them based on the way that they're showing them right now.
Patrick, can you zoom out? There's a little zoom there in the bottom right. And then scroll through those.
I don't believe I saw 4. 3 there. Okay. My only objections are to 5 and 7, as the dates listed at the top are outside the scope of this hearing.
Okay, hold on, because this is collectively mother's
Oh,
27. So I just want to be sure the record is clear. Is it certain pages of mother's 27 that you have the objections to?
yes, presuming they will be in the same order as they are right now, my objections would be to 5 and 7, as the dates go outside the scope of this hearing.
Okay, a response as it relates to pages 5 and 7 in respondent mother's exhibit 27.
Your Honor, the nature of her residence up through her brief period in Texas and then her departure therefrom is relevant. That's what these go to, Judge.
Okay, I think that's going to go to weight, not admissibility. So respondents 27, inclusive of all pages, is admitted. 16 seconds remaining, Mr. Wysocki.
Ms. Molly, do these exhibits, particularly 2 through 2 through 6, I'm sorry, the first page through the 5th page, show the child residing outside of Texas as of December 24th, 2024? I couldn't hear you.
Correct.
Okay. And so we see him in.
Do you want another minute to both of you?
However the court wants to do it. I mean, I can.
I'd like to have this explained, but I'm equalizing time each time. So you got 1 more minute with
Yes.
this witness, and petitioner will get the same 1 minute, and we've got a hard stop.
Sure. With regard to this image on the screen, had you departed Texas already at that time? Is that a yes?
Yes.
Okay. And where were you with the child in that photo?
That was in Illinois at our home.
Okay. And then in February, we see in 2025, were you and the child, the subject matter of this case, also at the home at that time?
Yes.
And who's pictured in that photo?
My husband and my daughter.
And then we look at Exhibit 4 on December 22nd, 2024. Where was this?
That was at the airport.
In Illinois?
Yes.
Okay, and is that when y'all had returned to Illinois?
Yes.
Okay, and then in March on this one with Chuck E. Cheese right here, where was that?
That was also in Tinley Park, Illinois.
Okay, so your son is having his birthday in Illinois, but it's claimed he was living in Texas.
Correct.
Okay, was he
right.
living in Illinois?
Yes.
Okay.
Okay, that's your time.
Judge,
Petitioner.
I need 1 more minute with regard to the testimony of that investigator.
All right, 1 more minute.
Okay. The investigator in this case claimed that your car had been license plate had been photographed in Texas by some website. Did you hear that testimony?
I did.
Have you even been in the country during that time frame?
No.
Okay. So how was it that you could have been driving your car in Texas as of even yesterday?
Objection calls for
I
speculation.
could have not.
Overruled.
Okay. And as you sit here right now on the screen, where are you?
I'm in Africa.
Okay. And you've been in Africa for a brief time frame right now, correct?
Correct.
Okay. So would it even be possible, her testimony about your car, would it even be physically possible for you to have been here?
No.
Okay. I pass the witness.
Okay. Petitioner, cross-examination.
No further questions, Your Honor.
All right. Argument.
Well, Your Honor, I'd like to offer my client for rebuttal.
You have 4 minutes and 20 seconds. Mr. Solis, you are still under oath.
All right.
Okay.
Mr. Solis, did you see that text message that you that was offered into evidence claiming you had not seen Malik since December 18th?
Yes, this is a Facebook message.
Okay. And when did you send that message?
I'm not exactly sure when.
Do you believe that it was sometime in 2025?
Yeah, it was after that.
Okay. And was that a true and accurate statement that you gave that you had not seen Malik since December 18?
Correct.
Okay. Now, earlier you testified that you were still in Texas until January 1, correct?
Correct.
What happened between December 18 and January 1 with relation to where Malik was?
So she would always hide stuff from me, and so I knew that he was gonna go spend Malik and Z, her daughter, were gonna go spend Christmas with Kais in Illinois, and that's when I had went down there, and I was Christmas in Frisco, December of 2024.
Okay. And so at that time, again, I think I already asked this question, but I just want to make sure I understand. At the time of December 18, between January 1, 2025, did she give you any indication that she was leaving the state of Texas entirely?
No.
Now, did the two of you guys ever text about domestic violence between herself and her husband?
Yes.
What did she tell you?
Judge, I'm going to object with regard to this.
Hold on.
Doesn't.
Sorry,
Objection.
Mr. Wysocki, I'm having a hard time hearing you.
Yes, Your Honor. Objection. Relevance exceeds the scope of this hearing.
Okay, that's overruled based upon the previous testimony as it related to questioning from Miss Molly. He can answer.
Can you ask the question?
Yes, what did she say to you about the domestic violence?
That she had lied to protect his name and his image. And we were just comparing it to my other kids' mom, how she always tries to destroy me as a person and as a father.
And there was a text message that actually illuminated this, is that correct?
Yes.
And do you recall approximately when this text message was exchanged?
No, I don't recall it with the
Do you
exact date, but after
believe-
2025 of January.
Okay. Well, after January 2025, or do you believe it was before 2025? Because it was when you and her were still in a good relationship, isn't that correct?
Yeah, it was before then.
Okay. Your Honor, I'd like to offer, oh, I'm sorry, before I ask that. At the time that you sent these text messages with Brittany, is this how you had her saved in your phone?
Yes.
And at the time, did you have any reason to believe that it was not Brittany communicating with you on that phone?
No.
Your Honor, I'd like to offer P7 into evidence.
Any objection to petitioner 7?
Yes, Your Honor, I object to improper authentication.
What's missing, Mr. Wysocki?
There's no relevant date. He said he can't give you a date. That was his direct testimony.
Response, Miss.
He one point told you 2025. He one point after his lawyer leading him told you maybe 2024. He doesn't know. And so, Judge, I object based on the face of the testimony.
Response, Ms. Neal?
Yes, the date is not required for authentication. The date would have just been required for purposes of scope, which that is not the purpose of this, is not sent, or the purpose of this exhibit is not to specifically state a date. It goes to the credibility of the witness.
All right, the objection to petitioner 7 is overruled. Petitioner 7 is admitted. A minute 48 remaining, Ms. Neal.
Yes, thank you, Your Honor. I'll pass the witness.
All right, you got 2 seconds. I'm going to give you another minute each.
Mr. Solis, you've committed domestic violence, correct?
Correct.
Okay. And in fact, you've been arrested multiple times for domestic violence.
Correct.
And you've been arrested multiple times for weapons charges?
Never.
Okay. What other things have you been arrested for?
I've only got a domestic violence and disturbing the peace.
Okay. You recall having physically attacked Miss Molly in August of 2024?
Objection, relevance.
Credibility of a witness is always relevant.
It'll be overruled.
Well, Your Honor, so far he has not lied about anything, so this does not go to credibility whatsoever. He's admitted to the domestic violence charges. At this point, again, they're just trying to be prejudicial at this point. This has nothing to do with credibility.
And Your Honor, it also goes to motive to lie. And that's why I was trying to offer those exhibits earlier concerning his domestic violence and him telling her that he would kill her and the child and all that stuff. Judge, it goes directly to motive to lie.
Okay, but hold on, please stop interrupting me. He has admitted that he was arrested multiple times for domestic violence. So why would going into a specific instance that he's already admitted to be further needed if he's already admitted to that?
His clear anger over the fact that she terminated any form of relationship with him, Judge, goes to, again, motive and credibility.
Your Honor.
Okay, as it relates to home state jurisdiction, that is your objection is sustained. Ask your next question, please.
No further questions, Judge.
All right, 248 remaining for the petitioner. Any redirect?
No, Your Honor.
Okay. Any additional witnesses or evidence?
No, Your Honor.
Close?
Yes, Your Honor.
Okay. All right. Go ahead, Ms. Neal.
Yes, Your Honor. So the UCCJEA specifically requests or requires the state where the child has lived for the 6 months prior to the commencement of a child custody proceeding be located in where the child has been. So the home state here, question for you is, where was the child beginning December 29, 2025 through June 30, 2025. Those are the dates that we're really looking at. So anything prior to that is not overly helpful to the understanding of whether or not Texas is the home state. Case law specifically states, and the UCCJEA, that when we talk about home state, brief moments away from the state does not necessarily change the residency. And so the overwhelming evidence that you saw today is that Texas has seen Malik far more than Illinois did in 2025. The only thing you have from Ms. Baumann is her testimony that he lived there the entire time. But what you see is actual records showing him in Texas on a frequent basis throughout 2025, going to Hope Fellowship. There are no records whatsoever showing this child in Texas, or I'm sorry, in Illinois. Instead, it's just testimony, which we believe that through some of the information provided today leads some credibility questions, specifically with relation to the Social Security numbers that have been affiliated with Ms. Baumann, as testified by Ms. Wickham, as well as the testimony just now that you heard about the domestic violence situation. So you do have to kind of weigh how credible the testimony is when you have hard evidence in front of you that this child was in Texas for the 6 months prior to June 30, 2025. So we are asking for you to find that Texas is the home state and to move forward.
All right. What says the respondent?
Happy to respond, Judge. The witness himself even said that he has not seen the child in the state since December of 2024, which is consistent with my client's testimony concerning her residence. With regard to that, we can look at his own communications where he, in late November, said, I saw boxes about you leaving. There's no claim that about some change of address in November. With regard to that, the claims is that it has been and consistently by Ms. Molly that she returned to Illinois with the child at that time and then made sporadic appearances in Texas thereafter because she was allowing her daughter to finish the school year in Texas. And we've maintained that consistency. With regard to Mr. Solis, if the court looks at his testimony or whether the court looks at his affidavits to the court can see that it is anything but consistent. Anything but consistent. He testified the last time we were in front of you on the special appearance that he lived here with her and the child through the beginning of 2025. And I actually had him I doubled him down on that statement. I said, you're telling this court X. Yes, Judge, he fully recanted that testimony today and said that he never actually lived with her, that we were living apart. His text message from December says, we haven't lived together in over 6 months. You have that. Judge, he has every motive to be dishonest with this court, and he has been. His testimony with regard to the child was one thing. His text message says, I haven't seen the child since December 18th. At the time he sent the text, there wasn't a pending court proceeding. In front of you, there's motivation.
All right, Mr. Wysocki, finish your last thought, and that's your time.
If we're going to rely upon any statements of Mr. Mali, Judge, they need to be the statements that he put in text. With regard to the relevant time frame, it has to be 6 contiguous months. There has been no testimony and no evidence showing a continuous 6 months of residence. At best, and by my calculation of what I've seen here, at best, we're right at 5 months but we don't get to 6 months. And so, Judge, we're asking the court to find that Texas is not the home state, and grant the plea to the jurisdiction.
All right, I've equalized time. Plaintiff, petitioner, you have 2 minutes and 54 seconds for your final rebuttal. Go ahead.
Thank you, Your Honor. Yes, further evidence that you would have heard today to show that she was in the state of Texas also was Mr. Hernandez, who testified that he saw and spoke with Ms. Baumann in April of 2025, specifically talking about living in Dallas. That is probably the most accurate statement of any testimony that you probably heard today, because he has no motive to lie whatsoever. Mr. Wysocki has not addressed any credibility issues with him, has not addressed even in his closing that you have any reason to not believe the testimony that you heard from Mr. Hernandez today, stating that he saw her in April of 2025 with the child at issue, specifically talking about what it was like to be living in the Dallas area. So again, going back to the consistency statement that Mr. Wysocki just stated, home state jurisdiction, to determine home state jurisdiction, someone does not have to live in a certain place consistently. They have to live there. If they leave to go visit other states, that does not disrupt the 6 months. So long as they continue to live in that state for 6 months, that is the question. So her leaving and going to Illinois with the child to go visit her husband does not disrupt the 6 months in Texas. Instead, what you see is consistently her going to church with this child in the state of Texas all the way through August of 2025. The testimony today has suggested that perhaps she left altogether at the end of the semester because that's when her daughter would have left, but that does not explain why she would have still been going to church as of at least August of 2025. Additionally, you have more inconsistent statements between Ms. Baumann, because her UCCJE affidavit that is on file with this court says that she left Texas November 1, 2024. And then she stated that she was leaving November 27, 2024 via some kind of a text message. And then she testified that actually they left Texas on December 22nd, 2024 to go back to Illinois. So right there, you have 3 different inconsistencies as to what date she allegedly left. The only consistency you've seen is the Hope Fellowship documents and Mr. Hernandez testifying that in April 2025, she was here along with Mr. Solis's testimony of what he has seen from her social media accounts. So again, I assert that home state for this child is the state of Texas.
All right. All right. Thank you all for your patience, especially with my Zoom issues. I want to take the time today to finish reviewing the voluminous documents that were admitted. I haven't gotten to go through all those, but I will have an answer to you by today at 5 p.m. Anything else from either the petitioner or the respondent as it relates to this matter?
The only other thing, Your Honor, is the DNA testing that we had asked that if we would be moving forward in the event that you find Texas to be the home state, can we also get a ruling on whether or not DNA testing will go forward?
And I'm happy to respond to that if I need to.
Go ahead, Mr. Wysocki.
Under the code, Judge, we would be entitled to a hearing. The statute with regard to a paternity when the child has a presumed father, which again, they misrepresented to you in their pleading that they still haven't fixed, that this child doesn't have a father. This child does, and under that statute, I'm entitled to a hearing on the equity, where I get to put on every single piece of evidence for as far back as I can go with regard to every criminal conviction of Mr. Solis, every gang affiliation. I get to put on all the rap videos he made, the recent one he made about lying to this court. And I can put on all these rap videos where he talks about all of that and everything else. I see he's smiling because he knows I have the video, because he thought it was real funny after the last hearing. So he made a rap video about it, Judge. And so I get to put on all that evidence at an equitable hearing where this court can decide in equity whether or not it would be appropriate to order genetic testing in equity. And so no, Judge, I would object to this court sua sponte ordering anything. And I would be entitled to a hearing at that time. However, I don't think we get there. This court is not the home state. And so to address that, the court can see, even from those records, as I pointed out to the witnesses, she was going to church every weekend, every single weekend up until December, in November, December, when she said she moved back to Illinois. Consistent with her testimony in those records, it shows after that, it was sometime.
Objection, I believe he's now going back into this argument, so.
No.
Okay.
The court asked.
Anything else? Well, hold on. Anything else on, from either side as it relates to the DNA testing? I hear petitioner saying you wish for the court to make a ruling based upon your pleading and request for DNA if the court finds that Texas is home state. I hear the respondent saying that he's entitled to a hearing on equity. Does the petitioner have any additional response as it relates to the respondent's contention that he is still entitled to a hearing on equity if the court finds that Texas is the home state of this child?
Yes, Your Honor. I do not believe it's an equitable argument. It would be an equitable argument if the child were over the age of 4. But because the child is under the age of 4, we are still able to challenge based on the Texas Family Code. So if the child were over the age of 4, this would be an equitable argument as to whether or not it would be in the child's best interest to potentially introduce a different father to the child at that point. But that is not what we're dealing with here. This child is under the age of 4 and under the Texas Family Code, testing and challenges to paternity are allowed.
And I'm happy to respond to that. It has nothing to do with whether the child, the case law is clear that the court can consider all kinds of evidence with regard to whether or not it's equitable. So for instance, there's cases where people in prison there's cases where, like this one, the person was a drug user, a gun issues, gang issues, etc. All of that evidence. And so it doesn't have to do with age. The case law is clear. It's all kinds of equitable grounds.
All right, here's what I'm going to do. I'm going to withhold my stance on that because we have a preliminary hurdle to jump. So let's jump that hurdle. In the event that the court finds home state, I'm going to look into both of your arguments. I might require additional briefing based upon your arguments. I'm going to attempt not to, just based upon the court's own review of whether or not I can order that sua sponte or what circumstances would require a hearing. So I'm going to attempt to do that on my own. I will let you know after the ruling if I also require briefing. With that, we are off the record. All right. Thanks, everyone. I'll have something to you by 5 o'clock today.
Thank
Y'all
you.
have a good
Are we all
day.
excused?
Yes, everyone's excused.
All right. Thank you.